So my name is Michael Martone. For those of you who I haven't met, I'm the town planner for Damariscotta and Newcastle. I recognize most of you, just so you know who you're sitting next to-ish. This is for the both the planning boards of Damariscotta and Newcastle, both of the appeals boards for Damariscotta and Newcastle. I invited the select boards for both, and also the Historic Preservation Commission from Damariscotta. So that's who you all are. This is Phil, and I don't remember. Saucier, Phil Saucier, who's with BernsteinShur. He is going to teach us everything that we need to know about planning and not getting in trouble with that. And he's gonna do it in an hour. So, but I'll let Phil kind of give you the spiel. It'll be an hour, 2 hours. We'll see how active and inquisitive everybody is. But yeah, if we haven't met, please, you're welcome to introduce yourself to me, but otherwise I'm gonna turn it over to Phil. But I just wanted to point out, Max is over there in the corner. He is with Mid-Coast Council of Governments. He's gonna be recording tonight, so, you know.
Please do not say any bad words.
Yeah.
At least while the camera's.
All right, then with that, I'll give it to Phil.
Thank you. And if you don't mind, I'll probably sit if you can't see, you all see me? It's fine. And I'll just give a brief introduction, so you know sort of where I'm coming from. My background is, I'm from Maine. I am the chair now of the municipal department at BernsteinShur, which has a fairly large municipal practice. It's one of the things we do. And so we represent towns and cities all over the state, mostly the central and southern parts of the state. As general counsel, and I'd say 90% of the work I do is for public sector clients. So that's sort of my client base. I work with planning boards and zoning boards and town councils, select boards, the whole gambit of municipal life. And in my personal experience, I sat on a zoning board for 7 years, chaired it for 4 or 5 of those years. A conservation commission. I'm currently on the school board in my town, and so I care a lot about municipal life, and I think it's an important thing to be part of and to participate in. So both my personal and my private life. Before I came to law school, I was just talking to the guys. I thought I was going to be a planner, so that was my head. I like planning. I'm interested in planning. I did a little stint at a private design planning firm before I went to law school, and so I still work with a lot of my contacts on a daily basis are planners, code enforcement officers. And people like that who work in those fields and planning. So tonight I'm asked to give these sort of trainings, discussions frequently. And it's going to be fairly general to start. I'm going to get a little specifics, but because we have multiple boards here, I was originally told it was just a planning board training. It's fine that it's not, because in some ways, a lot of the same principles apply to public bodies, regardless of, in some ways, which body you're sitting on. The first thing I'm going to go over is going to sound fairly general, but we call it sort of a tune-up. Sort of things to think about if you are for public officials, and you all are public officials in your roles. So just kind of some tune-up thoughts. I'm going to talk generally about conflicts of interest under the law, so you can recognize those, understand how to deal with those if they come up in your work. I'm then going to talk about Freedom of Access Act. That's just to go over that. For planning boards in particular, one of the reasons it's always good to be reminded of that, but planning boards in particular, the legislation now requires planning board members to be trained. There's a list of officials that are supposed to be trained, and a couple of years ago they added planning boards to that list. Not zoning boards or historic preservation board for some reason, even though it's a good idea to know about it because it applies to you. Planning boards are. So this will qualify for your training to the extent you're asked or ever needed to know about it. And then finally, I am going to get into a little bit of the last half of it is a little bit of board specific issues. So the kinds of things as a board member you should think about when you're looking at an application, hearing an application, making a decision. I'll talk generally about planning board jurisdiction and generally about zoning board jurisdiction and some thoughts around both. So that's kind of the general. I also do not mind, in fact, like being interrupted. I think it makes it a little more interactive. So as I'm going on, this is not a lecture. I'm just gonna, but if you have questions about what I'm saying or something that's come up in your board work, feel free to raise your hand. I think it sometimes makes it more interesting to suss out what you're thinking about and what kind of questions you have on your board work. Yeah,
Can I ask a quick question on that note?
sure.
When you say zoning boards, that's the zoning board of appeals, so appeals boards and is zoning.
That's
board.
right. I remember talking about, in Maine, we have really one, it's board, it's statute, the Maine law actually calls them boards of appeal. But depending on the town you're in, the ordinance, you see it called something slightly different, but they're all the same thing. So you see them called zoning boards of appeals, zoning boards, board of appeals, board of zoning appeals. Now one of my towns called the Board of General Zoning Appeals. So there's all different ways to say it. But they're all really an appeals board. And I'll get into some of the jurisdiction there, but thanks for that clarification. So I'm just gonna dive into sort of general boardmanship, tune-up. Think of it as a tune-up. And I think it's increasingly important today. There's a lot of attention on public bodies. We talk about that in my work. Obviously, we work with public bodies. We work with MMA quite frequently. I give a lot of trainings for MMA. It's South Maine Municipal Association. And one of the things I can just tell you, I've been practicing about 20 years now, is even in that relatively short period of time compared to some of my mentors, I have seen the tenor of public meetings change a bit in those 20 years. For better, for worse, I think, slightly more contentious. So that can sometimes come in front of your bodies. There could be applications that just have people have a lot of interest in. People have opinions and they have a right to have an opinion. But you'll see a little bit more, for lack of a better way of saying, a little more consternation in some of these boards. And so that becomes more important on how we conduct ourselves as public officials. I think, and it's a hard job. I just want to say, I've been in meetings, I've been sitting on that side of a table and also sitting with a board or as a board member. And some of these meetings can be very difficult. People have, will say a lot of different things. And I think the biggest thing to think about is your duty, right? Your first duty on whatever board you're sitting on is to your municipality and the public. And that goes a long way for people to really trust in what you're doing. And that's the important thing. So people can have questions, they can be upset about the project in front of you. But at the end of the day, if they know that you are doing your best, you're following the rules, you're trying your hardest, that goes a long way to establishing trust in the body. And to that, you really should not let your personal feelings, and this is going to delve into conflicts, personal feelings get involved. You hear the application, you look at their ordinance, and you determine whether the applicant meets standards. And really try to take your personality out of it. Select boards are a little different, I suppose they do. Some select boards are here. Select boards have a policy role, right? It's a policy part of select boards. And so personal decision, it actually comes into that a little bit more. But when you're talking about a quasi judicial board, like a zoning board or a planning board or a historic preservation board, you really are supposed to take the personal out of it, and be more dispassionate. To that end, and some of this is obviously, and I know you guys are always like this, but I have to say this, civility goes a long way in courtesy. Sometimes that does not happen, and honestly, that's when you start to lose the room, if you will. People, and there can be a back and forth, and then the trust breaks down and the process breaks down. So simple stuff that I know everyone knows, but I think it's good to be reminded that to conduct yourself in a civil way with courtesy. And to that end, courtesy and civility also comes along with process. So not every board in Maine, and we have informal, we're small towns, not everyone uses, for example, strict Robert's Rules of Order, but you use a form of it, even if it's a less technical version of it, but to keep some sort of order in your meeting. The basic of, making sure the audience does not speak while other people are speaking, that the chair is the person running the meeting, that people address each other through the chair, the audience, I should say, and the applicant through the chair. And because that takes the personal out of it. And that can happen. I was just at a meeting earlier this week where that started to happen. And it was where people were reminded to ask your question to the chair. The chair can then ask the person in the audience the question. To get into a back and forth. But here, remember, it is a hearing of sorts. So all of our meetings are open to the public for the most part. And certainly for almost everything but a select board would deal with. I'm gonna get a little bit more into the Freedom of Access Act, but just remember, public can come in, public can see what you're saying, the public can tape you. Some of it can feel uncomfortable. Public can ask for your documents that you're looking at during a meeting. But that actually also, that idea behind that is it gets the public trust. They get to see what you're doing.
When you say that all of the public, do you
Yeah.
have to be a citizen of the town to come and speak at the planning board meeting or
No.
ask questions?
No, so the only time that applies is town meeting forms of government at the town meeting itself.
At the town meeting
And
itself.
that's because you're voting. So you have to make sure that you understand who is in the audience of the vote counts. And then, as you know, typically town meeting votes to decide whether to let someone speak who's not a voter.
So,
But planning boards, zoning boards, those kinds of things, those are all public and anyone can come.
so an individual doesn't have to have standing laws.
That's right to speak. No, yes.
Yeah.
Yeah, you shouldn't sort of decide who can speak or who can't speak. And in fact, generally, some of these meetings, they're general issues for the public, and so it gets people from all over potentially.
Mhm.
The applicant may not be a resident, for example. So yes, anyone can speak. To that end, just because it's a public meeting doesn't mean that people can speak whenever they want, however. Or if there's not a public hearing portion of that meeting. So the public does not have the right to speak if it's not the time to speak. That's an important thing to remember. I know there are different customs in different towns. I work in enough towns to know. Some towns have a very open back and forth at every single meeting, and that's just the way they've always done it. Other towns do not do that, right? There's a time to speak. Sometimes there's a general time to speak or before each agenda item or whatever, but the idea is that you should really remind people they do not have the opportunity to speak unless it's the time to speak. There's a public hearing, for example. If you have time, we always recommend deference to more time. That can be difficult sometimes, but it's okay to have a limit. If you have a lot of people in the room, 3 minutes, you'll see 3 minutes, 5 minutes. That's okay. It's sometimes actually a good idea, particularly if a lot of speakers. But to the extent that really someone just needs to speak a little more, always, I would say, allow speaking. Because that goes a long way to sometimes tampering down any potential appeal, quite frankly. Some people, people want to be heard. And if they feel like they don't be heard, or they're not heard, that's where we sometimes see the process breaks down and maybe there's an appeal where you may have not needed an appeal. This is an important one, which is the evidence that the matters you're looking at and you're making decisions on need to be based on the information that's in the packet, in the room, the testimony in the room, in the packet. That's a frequent issue. It's actually kind of difficult to understand at first if you think about it. People, I think, well-intentioned board members want to go out and do their own research to bring, to really understand the issue, to grapple with the issue that's in front of them. But that's the courts have said that's a violation of due process. It's actually a constitutional violation for the applicant. It doesn't seem like it should be, but it is. If you think about it. And the reason why is because people need to know what information the board members are just making their decisions on. They have the right to see the same information that you do and to respond to it. And if an individual is going out and doing their own investigations and research and bringing that, well, the applicant, for example, or the butter doesn't like the project, wouldn't have the opportunity to engage with that information in the same way if it wasn't already in the packet. So if you don't have enough information, maybe it means you deny the project. But you don't go out and find the information yourself. You can ask the applicant to provide more information. You can ask the staff sometimes to provide information, but you shouldn't be doing your own research.
Isn't that one of the reasons the planner can have a checklist of things that typically
Yes,
the board will need to see?
that's exactly right. That's exactly right. And that frequently planners are asked to bring more information to the board. That's the channel to go. And then when information is brought by a planner, everyone gets to see it, right? So it shouldn't be. I actually had this question from a client today, is that one member wanted to talk to the code enforcement officer in a zoning board context. And I got a call from that code officer. It's like, should I answer that question? We're in the middle of a proceeding, it was tabled. And I said, no, but to the extent that the board needs more information, the chair can ask for information. You can provide it. It's then given out as part of the packet. So everyone on the board sees the same information and the public sees the same information. And there's nothing wrong with that, as long as it's just disclosed that way. And you'll see updates in packets, for example, and from meetings. So there's nothing wrong with more information, just that everyone gets the same thing. The courts have overturned decisions when a board member goes out and does their own research. That's a cause for overturning a decision if their vote was partially based on that additional research. This is a nuance. That doesn't mean you don't bring your own personal information. Yeah, I mean, your own personal knowledge, I should say. Information's the wrong word. Your own personal knowledge to everything. We all do come with our own backgrounds and our own expertise and our own experiences. That's normal, and that's why it's actually good to have a board with various experience. So if you're a realtor, you're clearly gonna know a little bit more about the selling of the property, right? If you're an engineer, if you're whatever you are, a teacher, you're gonna have that perspective. That's okay, but you're not gonna dive deeper into that application outside of what's presented to you.
Can I ask
Yeah, please.
if a board member does come across or find information that's relevant, is there some way, some mechanism that they can like enter that into the record, so to speak, and how might that work?
So, yeah, the way you do that, so the general rule, again, is I say, don't do that. But if there's something that does come to you, or you did find something, what you do is you disclose it at a public meeting. And you let everyone know the same information you know. And I have seen that from time to time, but I think that's the way you would try to fix that kind of issue that would come up. Is I have this information about this project. I want the applicant, I want the board to hear this, I want the applicant, members of the public to hear it and give them an opportunity. And if that means that it's enough of a big piece of information that you give more extra time, then table that item and allow them to give a response to that. That's how I handle that.
You wouldn't
Yes.
give it to the staff or the chair and have them?
That's the other way to do it. Either, so yes, you would give it to the staff to distribute. The only reason I don't sort of want to go down that road too much is we shouldn't be in the habit of providing staff with information to distribute. Because again, you, as a board member, you really should not be providing information at all. And this is just a rare experience where maybe someone, where I've seen it, where it's like, it's not something you did personally, is some members of the public might pass something out to you as a board member. They want you to know. Well, that's something you should then give to the, thank you. Or you either say, could you please give that to the staff member, or you give it to the staff member, say, I was given this as it relates to this application. So make sure everyone gets it, so everyone has the same information.
In a way, isn't it?
Yeah.
If you're on the planning board or the board of appeals, you're acting more in an adjudicative role rather
That's
than a
right.
legislative role. You're not
That's right.
making policy on the point.
That's exactly right. That's a very good point. I'm gonna get into that a little bit more, but that's why it's important to be neutral in this way, and you're not researching things like that. Yeah. Some of these again are basic and you all know this, but we apply the law as written, whether we like it or not. We can interpret it. Our job is to sometimes interpret what the meaning of the words are, but we can't, what we say in the sort of trial context, there's no jury nullification. We can't just decide we don't like that provision, and so we're not going to apply it to this applicant. Our town laws are ordinances, they're passed by our legislative bodies, and you have to apply them. I remember once when I was on the board, I didn't think that there was a fair result, and I felt the need to say that. I was voting against an applicant, but I didn't think this provision made sense, and I just said, you need to go in that case, it was a city, you need to go to the city council and get that changed if you don't like, if it's not good, right? But our job is not to overturn it, we have to apply it. So that's something to remember when you're going through an application. That could be challenging because you're often on the firing line. I see this all the time. There is often public pressure in some of these applications to approve or deny an application, depending on the tenor of the audience. And you really have to just apply the ordinance as it's written. I'm gonna get into a little more detail on that. Finally, in this sort of very general overview part of my presentation is conflicts of interest. Again, it's both a legal requirement, but it also gets the general idea I was talking about of engendering trust in your work from the public. So the public trusts and believes in what you're doing. Is you should not be acting on any application where you have a conflict of interest. That is a term that's defined under Maine law, and it's defined in a couple of ways. First is what we call a pecuniary conflict of interest. You have which is financial interest in the application, and that's defined by statute. It's a black and white test, and that's if the applicant, if you have an interest in the applicant in front of you, that you're an officer, director, partner, stockholder, any kind of business interest in that company, and that you're directly or indirectly the owner of at least 10% of it. That's actually what it means. That's a financial conflict. If you own at least 10% of that company and you're in some sort of leadership role. That's a de facto conflict and you need to step aside, because if you don't, there's a very good chance that the decision will be overturned if you vote in favor. That is the easy one to find out. The harder ones are the gray conflicts of interest. That same statute also goes on to say you need to avoid the appearance of a conflict of interest. Attempt to avoid. So what that means is not every time, there could be appearances can be in the eye of the beholder, but you need to address it. So what that will often come up, the member of the public raises it, or you even know, in this, and again, we all basically know each other. So there's sometimes you'll have people in front of you that you went to school with, you deal with in some way. You're not an owner of the company, you're not, an interest, but people know that you guys know each other. And so to avoid any appearance, you should disclose that, address it. And the way that goes is you ask yourself a few questions, which is you'll say, look, I know Bob, he's, I've done some business with him in the past. Maybe I hired him for something. I have no interest in what he's doing here today. I have no interest in that. I have no part of it. And then you ask yourself, I have no bias or predisposition to what he's asking for tonight. And I think I can sit on this board in a way without any kind of bias or predisposition. If you have to ask yourself that question, and then you say that out loud. And then the board actually votes on whether you should stay or not. That's the way the process is supposed to go. That's it. So they are airing it. Everyone understands it. Yep, we get it. I don't have that. And then nothing is hidden. On the other hand, if you feel like you are biased, then you should say, I really need to step down. Sometimes it's obvious bias. An obvious bias is you signed a petition against a project. I've seen it, right? You actually signed the petition and now it's in front of you. Then you need to step down, right? That's an obvious and conflict of interest, and you really should not be part of that application. You've already decided you don't want it. And you can't, and you shouldn't be sitting in front of a project if you've already made your decision before you've looked at the ordinances and heard the evidence in the record. So that's a sort of more biased. So it's really, in some ways, it's a question for the board member to ask themselves. But the answer is always disclose, always have a discussion, and then have a vote on whether, if you decide you can stay.
If you have a client that is putting a petition before the board, can you look at it and rule on it, or do you have to say, no, I can't?
Is this like in a select board context, or?
It would be in planning board, say, he has a project.
Yeah.
And wants to have done, but he's your client also.
Yeah.
You're not necessarily working directly on the project itself, but he's a client.
Well, that's at least something you need to disclose, and you need to go through that. So I could see how you may or may not need to step down based on the circumstances. So it could be a client of yours but you work on completely different issues, right? You have a business relationship, but you have nothing to do with this project in front of you. You have no bias or predisposition. If you could say that honestly, as long as you disclose it and the rest of your board agrees, you can sit. On the other hand, if it looks just too close, right? It's a client and you have some sort of financial back and forth, and maybe if there's an indirect, it will be indirectly benefit you.
Well, he does pay you.
He pays you, and then that clearly at least is an appearance of a conflict. And it's probably best under that circumstance to say, I'm going to step aside.
Even though it's.
You want to preserve the integrity of the process. That's what it comes down to at the end of the day.
You're saying if you sign a petition,
Yeah.
then it comes before you, you'd have to disqualify yourself.
You should, I should say.
But suppose the Board of Selectmen is a legislative function.
Yeah.
Suppose there's a controversial issue in your community, as there's been lately.
Yeah.
And you take a position on it, and based on that, you run and are elected because you took a position. We wouldn't say a congressman can't vote on
That's right.
issues that he legislates about. And yet I've seen a recent specific example, I won't say which it is, but where a person was told he couldn't act as a selectman on a topic because he voiced opposition to it and ran and got elected on that basis. And that struck me. It was on advice of counsel that I think was misspoken.
So, yeah, and I'll speak generally, and that it sounds like there's a very specific thing there, but I agree, and I think I touched on earlier, select boards or councils are a different type of body than the adjudicatory bodies of planning boards and zoning boards. They're not always different, but mostly, because some select boards sometimes do sit in the adjudicatory.
So a person
Office.
doesn't have to disqualify himself.
Just because you have an opinion about a new ordinance or not, for example, policy, you're absolutely right, and there is a distinction there. What I'm talking about, this conflict of interest is when you've got an application in front of you.
Yeah.
So in the legislative body, or I should say the select board,
Yeah.
that would be a contract you're voting on whether to enter into,
Yeah.
right? It would be liquor license and those types, there's a few types of applications.
Or
the
to
select
pursue an
boards-
appeal.
Or appeal, sometimes there's appeals that go before the select boards, right? So when they're sitting, when they're sitting as a adjudicatory body, they need to make that disclosure. If you're talking about general policy of applicability or new ordinances, that's your job is on opinion. That's the way I look at it. Your job is on opinion. That's a policy, it's of general applicability, not a specific applicant you're talking about. So that's one way to think about it in your head. Two other types of conflicts, and it's sort of in general, is this and I touched on a predisposition or bias, if you have a prejudice against something. So not only is there appearance of conflict because of interest of some kind, but you actually are, this is the sort of, I signed a petition against that new housing development, right? And then this housing development is in front of you. That's an obvious one. You can see someone's name on it. There's another one, which really is personal to the individual. You can't always get in someone's inside your head. So it's something for you to ask for yourself, but if you feel like you can't, you really don't, and that's okay, people have opinions. You really don't like that thing, right? You just do not like it. And you don't think you can actually be unbiased as you go through the standards, for example. Then you should probably think about whether you should step away. That's considered predisposition or bias, and it's a type of a conflict of interest. That's for the individual to determine, but really remember your job as we started this is to apply the ordinances, whether you like it or not. And that may mean that you vote in a way that you wouldn't have actually wanted to if you didn't have to follow those rules. So that's another thing for you to think about, and that's for each of you to come up on your own and decide whether you need to recuse or disqualify. And then finally, this is another one of the other few de facto conflicts, like the 10% interest test, and that's familial bias. And if you're related to the applicant, then that's actually considered a de facto, you should step away. You can't, you don't go through that same analysis. Well, I know my son, but I think I can, you don't go through that analysis. It's in the statute. You should step away. It's a conflict of interest. And it's a family member. And the test is essentially second cousins inclusive. It's called the 6th degree of consanguinity. It's the only time the word you learn in the trust and estates class in law school. It's the only time I use it. Consanguinity, your relationship to generations. And a 6th degree of consanguinity, which is essentially second cousins inclusive. Once you get outside of that, I guess the law is saying, well, maybe you don't know them that well, and you can go, but you still have to go through that analysis of like, can I be unbiased at that point? Finally, what if you don't abstain and there is a conflict? Well, the decision can be voided by the court. That's the remedy, and people will, and you'll hear attorneys, and like I said, I don't often take private clients, so I don't have to be the guy standing up and arguing in front of the board often. But you'll see it, I just tell you this because sometimes they're not always trying to be a difficult person, but they're preserving the argument for the record. So you'll see attorneys sometimes say, I object, there's a conflict here. I understand the board's deciding that there isn't, but I'm object, I believe there is a conflict. And what they're doing is they're preserving that so they can raise it again if they appeal to court. And when they appeal to court, that's one thing they're going to argue, and the court can decide, and the court agrees, they're going to overturn the decision. So that's one of the penalties, if you will, if you don't comply. Any questions about conflicts of interest? Come up. Can always circle back, but okay. Freedom of Access Act. So again, this that is Maine's open records law and open meeting law, FOA. It's a little pet peeve of mine. You see FOIA, that's the federal law. But people say it says FOAA. You'll see it written that way a lot in Maine. Freedom of Access Act is what we call it in Maine. And it's the general rule, and the declaration of intent of that statute is that the people's business is public. And it directs the courts and attorneys who help interpret it, that it needs to be liberally construed and applied to promote its underlying purposes and policies. So if there's ever a dispute under FOA, you fall on the side of disclosure. If there's a gray area or an interpretation issue, you're directed even by the statute to say you need to look at it on the side of disclosure. So that's just something to think about from as an overarching. It's broken up into two segments. So public meetings, there's called proceedings in law, public proceedings, and public records. Those are the two sort of areas it addresses. There are training requirements, as I said now. Planning board members are one of them. I think code enforcement officers were added. The legislature adds to this every single year, by the way, so you have to kind of keep up with FOA. There's an actual standing committee made up of various members of the public, the media, legislators, that reviews it. It's a statutory committee, goes through title by title by title of Maine law and reviews on whether things need to be updated. Every year it gets tweaked one way or the other. I'm going to talk first about public proceedings, public meetings. So we start with the premise that every meeting is public. People can come in here right now if they want to, and watch the meeting if they want to, even if it's not a member of this body. Again, you don't have to be a resident. It can be anybody. And a meeting means any transaction of governmental functions of a body. So not just 6 random people in town, not 6 employees. So it doesn't apply to employee meetings, for example. People can't just walk into the town manager's office. They try, but they don't. You have a right to exclude them from those kind of private spaces and workspaces. It applies to public bodies. So you guys, they're appointed. All your boards, all your subcommittees, temporary boards, advisory boards, every single board. We typically define a meeting as when you have 3 or more people of that board meeting. That doesn't mean that 2 or more, you shouldn't be conducting business in a way you shouldn't be conducting it, but a meeting is when you have at least 3 of the members there, or a quorum. It's a body of 3. If it is a meeting, the statute requires you to publish notice, so members of the public can find out that you're meeting. It's actually pretty vague on what that notice looks like. Some towns have their own notice requirements, so they supplement that in your ordinances. It has to be 7 days ahead of time. It has to be in the newspaper. It has to be all kinds of different things. But the statute, actually, the FOA statute just says it has to be disseminated in a reasonable way to notify the public. That's all the statute says. So more and more that's email, websites, things like that. There's still the old school posting on the board too. The only time emergency meetings are allowed, so you can, even though you have a regularly scheduled meeting, you can have an emergency meeting. You just have to, what the statute says, you have to notify members of the local media, essentially at the same time that you're notifying the board members you're getting together. So we still do have media. They're important. Used to be more media coverage at every single one of these little meetings. You see less of that, but there typically is a listserv that the town has where people are on, and so you have to send that email list to say we're meeting really quickly. And I often say it's so easy nowadays. You just have an email distribution list. You have a website. Post sometimes use even Twitter and things like that. Just put it up wherever you are. You need to meet today and let people know. The last thing you want is for people to think there was some sort of clandestine, unnoticed meeting. You need a record of the meeting. There's a lot of discussion about what's in the minutes. Would you need minutes? Technically, you don't need minutes under FOA. What you need is a record of the meeting, and there's very basic information that you're required to have in it. You need the date, time, and the place of the meeting. You need the members that were in attendance, and you need the motions and votes that were taken.
Do you mean number of members or names, actual names?
The names of the members. Identify who was there of the board. You don't have to identify the members of the public. Some people do that as a matter of course. It's the members who are in attendance. It used to only be a written requirement, but now audio and video actually satisfies that requirement. So if you're taping it, and you make that clear somehow during the meeting, just those 3 topics, that actually is your record. I still think it's a good practice to have even a basic written, so that, you know, because not everyone has time to go sit and listen to every single thing. At a minimum, minutes are a good sort of quick, what did they talk about, right? And I can go back and listen to it if I want to. But I get questions a lot about, you know, some towns really, I mean, they write novels. And they really do, they try to get every word and never, and other towns don't, they'll just say motion. Actually, they just take the agenda, they'll just use the agenda and that's the minutes and they say what vote happened at each one. Maybe something in between is good. I actually err on the side of less in minutes because there's less way to misinterpret what people said. I've seen recently a couple places I've been, people get angry because one person's comment got into the minutes, the other person's didn't. Right, and so minutes, I see it as a basic tool to say what happened at the meeting, and if people want to go back and listen to it, we tape these more and more, or video them more and more, and that's what we should do. The public's allowed to record, I mentioned that, we get those questions from time to time, that's right in the FOA statute, so someone can come in today if they want to, they can put a camera right here. The only thing it says is they can't interfere with the proceedings, so they can't put their equipment or something in a way that would interfere with my ability to talk right now and to disrupt the meeting. But they can record and people do.
A question about the minutes, though. I'm on the appeals board.
Yeah.
I get a package in front of me, and I don't have a clear picture of what took place because two or three of the meetings that the planning board had on this, there's no minutes for.
So there should, like I said, there should be the basic minutes at a minimum, so you know what applications were
But
were
it's not,
referred.
you say should.
Well, you have to have those three things. You need to have the date, time, and place of the meeting. You have to have the members who are present and the motions and votes
So
taken.
you have to have the minutes
Yeah.
of those meetings.
Yeah, those would be what we would think of as minutes, or people would call minutes.
Mhm.
You don't need to go beyond that,
Right.
but I like,
I
I said,
understand
sometimes like
the
to.
content doesn't have to be.
That's right,
separated, but-
that's right.
But you do have to have something there that says we held a meeting at that time, and this was the outcome of our determination.
Yes. But as I said, and this wouldn't necessarily satisfy what you're looking for in a piece of paper, you can actually satisfy that now by a visual, by an audio or a video.
Would.
That actually satisfies that requirement, yeah. Yeah, but I still, again, I still think it's a good idea to have the written basic
Mhm.
notice. Under FOA, and I mentioned this already too, there's a right to attend, but that doesn't give you a right to speak. So depending on the context of the meeting, if there's a public speaking portion or not. For example, some boards have workshops, so there's never an opportunity to speak. That's a working time. People can come and watch you. It doesn't mean you're allowed to speak. One exception, I'm not gonna get into it a lot, is our executive sessions. There's an exception both on the public records and the public meeting side. And that's when you are allowed to meet in private and exclude members of the public. It rarely happens for planning boards and zoning boards, historic preservation boards. I've seen it from time to time in very limited circumstances. For example, if there's a court order remanding something back and you want to discuss, what does this court order mean with your attorney? But that's about the only time. Or some sort of some specific types of training where you get to a legal issue that's been right. But really it applies to select boards and councils because there's a lot more opportunities for them to talk about things. The issues you can only go to executive session under the reasons in the law. You have to point to it. In fact, you have to cite to it. Select boards are very good at that. They know how to do that now. You have to cite to the specific statute, and those are, just to give you an example, labor negotiations, employee issues, real estate transactions and sales, because it would put you at a disadvantage if you're openly talking about how much you should pay for or sell something. So that's one of the executive sessions you can use. And then where I come in a lot is legal issues, not so much generally. To talk about legal rights and responsibilities, that's when you see boards having a discussion with their attorney about a particular issue, but that's one of the reasons you could meet. You have to say a description of what you're going in for generally. You've got to have a 3/5 vote to go in to executive session, and you can't make any decisions in executive session. But any decision still has to be in the public, again, so the public knows what you're doing. You can give general direction, you'll see that a lot, like general direction, for example, the attorney who's helping with a case, but there's no votes, there's no entering into contracts, there's no approvals or denials, things like that in executive session. Remote meetings, I'm almost done with public meetings. Remote meetings is a new thing. I started doing this about 15 years ago, and I used to have a section that said it's not allowed. You're not allowed to do that. And the statute, and the legislature was starting to kind of, interestingly left that little, they had like FAME, Loring Redevelopment Authority. They were starting to give like certain types of boards the authority to meet remotely where it made sense, but specifically disallowed everyone else. Now, of course, we're all used to it. We were given that authority. The law's changed 2 or 3 times since it was originally enacted, and at this point, it's pretty broad authority. It was before, it was when it was originally enacted during COVID, it was limited to emergency purposes. And when a member was ill or out of the jurisdiction, there were specific reasons you can meet remotely, or a person could participate remotely. Now it's for any reason. But the board still has to have a policy. That's one of the prerequisites. You have to have a remote meeting policy. And if you meet remotely, or any one member of the body chooses to meet remotely, then the public has to be given that same opportunity. So you have to open up the Zoom to everybody, if even one member is part of that. Every town's a little different here again, because it's some towns I know kept the emergency only language, they're not required to. They really want people in person, so they said, sure, still a good tool. I personally think it's a good tool for a town to have, even if you don't use it all the time, because you can use it for quorum purposes. Someone might be out of the state, but you really want to hold a meeting and they're able to participate. They're sick, but they're able to participate. They're not, too sick to not participate. There's still good reasons to do it. It's really good for emergency meetings if you really have to get together quickly on something. So I'm not gonna go to a lot of detail of that, but it's long and short of it is we're allowed to do that now as long as you have a policy. And then finally, and this is in the meeting section of law, any decisions you make in a meeting have to be in writing. And specifically conditional approvals or denials. It's written that way. I think obviously approvals do too, but conditional approvals or denials, and that's because you're in a conditional approval, you're saying sure, but you have to do A, B, and C. In a denial, so you're saying no, and you've got to give the applicant a reason why, so that they can decide. I'm getting more detail on that particular issue because that applies to boards. You have to give people the ability to know why you're making a decision, so they can decide whether they're going to appeal or not, or to better understand your decision. There are little issues I just like to bring up. So where you see issues come up are people talking in the grocery store about the application. Three members. I mean, actually, not even 3 members. That's if it's 3 members at the meeting, and you should be noticing that meeting. Even if it's a grocery store, people can come. It's actually a couple members talking about that application and how you may want to vote or not vote. And that's one of the areas you see some issues. You shouldn't talk about an application. Policy is different. But you shouldn't have to talk about the application. The application be talked about in the room that you're meeting. That's it. Just remember that, both on email or in person. Just do not talk about it, because that's where you get in trouble. That's the biggest violation that I see in this area. So avoid substantive discussions in email in groups of 3 or more. I'm going to turn to public records now, unless anyone has any comments. So public records, same idea. Now we're talking about documents. Same premise. We start with the premise that every document conducted for governmental business is public. You start with that general premise. And again, now it's frequently more electronic than paper, but it's paper, electronic, any medium. It's got to be the possession of a governmental official. So all of you would qualify in that regard. In other words, FOA does not apply to a private citizen. So they may have a government document in their hands, but you can't FOA them. Right, that's their right. We use FOA as a verb. Request the documents. You can request the documents of public officials that are holding governmental documents prepared for in relationship to transaction of public business. The staff deal with this all the time. Board members less so, but it does apply to you, particularly if there's something of a lot of interest. People becoming more and more. We're seeing FOA requests. It's actually a very big time commitment for staff from the state, and it's a good thing, but it is taking a lot of time. It's the people who have the right to see these would get FOA requests. I can't tell you how much of my practice now is people asking about FOA requests. People want documents all the time, and they have the right to request it, and you don't have the right to ask them why, or that you're not a resident, or that there are corporations, that an individual, any entity can ask, and they don't have to say why. Now, just like on the public meeting side, there are exceptions. So you start with the premise as public, but there are exceptions. So confidential documents, that's what we call it. And I'm not gonna go through all of them, but some of them are like individual social security numbers. That's an obvious one. The town has those for some reason. They're gonna redact it if it's in a document. There's other ones like certain, poverty abatement requests are actually considered public, juvenile records, certain police records, certain things like that. Negotiations between a public employer and a labor union. Criminal investigations is an area where a lot of requests come from. The police departments are getting them all the time now. And then finally, there's, I always like to talk, just generally, people think that everything I do as a public sector lawyer is confidential, and it's not. Unfortunately, from my perspective, we don't have the same level of attorney-client privilege as my private sector clients, private sector colleagues. Because again, there's this premise that what we're doing is public. So some of the stuff I communicate with a public entity can be considered attorney-client privilege, but not everything. And the exception in Maine is it's got to be sort of in anticipation of litigation, anticipation of being part of litigation. That can be somewhat broad. Sometimes we're asked questions because you're trying to anticipate, there's some anticipatory threat of litigation. But I always write, as you know, my role, I write to a lot of town managers and planners. I always assume what I'm writing is going to be disclosed. And oftentimes it's they want it disclosed. It's to help a board understand something or, to provide information like that. But that's in theory, some of the attorney-client privilege documents will be withheld as well. I already said, you can't ask why, it doesn't have to be in writing. And then there's a process, which I'm not gonna get into tonight. There's 5 days you have to respond. You gotta give an estimate of time. You can charge $25 or more after the first 2 hours. That's all staff takes care of that side of it. On sort of the process side, you can now ask to have prepayment. If it's over a certain amount of time, it's gonna cost $100. You can now, and this is also new, you can ask, if they haven't paid for it, you can ask for a payment before you give it over. But that's all these are the kind of questions we get. Each town has to have a public access officer who is that point person. And so you may hear from that person if someone says they want everything related to that application before the planning board. Both the staff side and the board side. So you'll hear from that point person to say, please look through your records. Yeah.
Could you just say a little bit about how deep FOA goes? Text messages on personal devices, emails on personal laptops and such,
Yeah.
voicemails.
Everything.
Oh, I know.
Yeah.
I'm just like, I
Yeah.
wanna just tease
It's a
it
good
out
point, yeah.
because I think a lot of people are under the mistaken impression that if it's a text message,
Right.
it's protected.
That's
It
right.
can be hidden and it cannot.
That's exactly right. It's a very good point. And also people are sometimes under the impression that if I use my Gmail account somehow, even though I'm actually talking about government business, that's somehow protected.
Yeah.
There's, FOA doesn't care what the URL is of your email, right? It doesn't matter. Many towns are moving to giving out email addresses, and I don't know if these two towns have or not. Even smaller towns are starting to move in that direction, is to have email addresses for every board member. Because it's good practice to then just say, okay, whatever, I just want everything to go to that account. So then you're not in the position of having to go through your own Yahoo account, Gmail account, text messages, and just say you're only communicating on governmental business under my Newcastle.gov, email address. The other benefit for towns is that they can look without you even knowing. But that actually is a benefit because it can take hours and hours to try to sort through everything. And so I want everything between, Jim and Susan as it relates to that housing development from these dates. Right, and then you need to do it yourself. And so now what a lot of towns are doing is they have an IT person just go in and query and yank it. And then they have it. And then the job is to sort through it. The staff member, sometimes we are asked to do it for various reasons, but you sort through it and say that responsive is there confidential stuff in there. But in some ways it's easier so that if you didn't do anything on your personal, you don't have to go through it yourself.
Handwritten notes.
Handwritten notes, you have them. And some of that depends on the request, right? Sometimes the request is for very specific things and they're not asking for something that would be on a handwritten note. But if it's I want everything in the world, universe related to this topic, then yes, you'd have to look through your handwritten notes. Yeah.
How long would you have to keep them for?
I don't have the specific answer for you, but there is a schedule under the Maine State Archives actually is the agency. that, if you go on their website, they have something called the municipal schedule, retention schedule, it's called. And it's surprisingly detailed. I think the general rule is about 6 years, I'd say, but there's some things that are one, like, there's some things that can be thrown away immediately. Like, for example, I think some of the planning ones, like you have copies of plans, like site plans, that you have another ones that says you can throw away the copy, like it gets pretty granular. Birthday cards, it'll even say like stuff that came in, 30 days, certain originals are forever, like vital records. So so what I do is I go to that schedule if that's a specific question. But yeah, Maine State Archives municipal retention schedule, and you go through and look to see what you need to do. More, I think that there's a movement towards electronic, so they're moving to say you can start to destroy things that aren't originals. As long as it's put on a server of some kind. Violations, decisions about FOA can be appealed like everything else. You can appeal to court if a municipality denies the request or the requester thinks you're not giving everything over. You can file a Superior Court. And a willful or knowing violation is subject to a penalty of relatively low amount, but attorney's fees. And there was actually a case just last year, one more. There's not a lot of cases in this, but this case awarded a significant amount of money to a requester because this particular agency, I think it was a county, decided not to turn over certain documents. And the court said really were public documents, and it was willful. And so it was, in the tens of thousands of dollars that the county ended up having to pay for that. So again, FOA is, I call it a living, breathing law. It gets amended all the time. That list of confidential documents gets added to from time to time, depending on the various issues that come up. So we have to kind of keep on top of it. Thought I had a list of some recent ones, but ones I can think about are, from just sort of random, like, zoning board people know that there's disability variances. Well, that was, someone realized at some point, well, these people have to give over medical records sometimes to show they have disability. So now the medical records that given to zoning boards for disability variances are now one of those excluded documents. So what will happen is there'll be a policy issue discussed in the legislature, and then they will put it in the exempt category. That is FOA. Any questions? Okay. Finally, your boards, what do you do? That's what I'm gonna talk about that next. I generally said about planning boards, but I can easily jump into zoning boards as well. I work with them both frequently. So the first thing you do, whether you're on the historic preservation board, planning board, zoning board, where you start is to think about your jurisdiction. What was your board given jurisdiction to do? Courts do the same thing. The first thing a court does is, do I have jurisdiction when someone files something in court? And so I like to look at jurisdiction for the boards. And actually, I actually like to sometimes start with select boards. My trainings are change over time because there's always something in a community where like, oh, select board's getting themselves involved in planning boards. Can you talk about select boards shouldn't be doing that? So now I talk about select boards. But I change it depending on the community. But the select boards do have a general role, and that general role is more on the policy side in the planning and areas that you guys work in on your board. It's limited. The select board should not be getting themselves involved in the actual applications. That's you are independent boards, right? But they have a role of adopting a comprehensive plan, which is a prerequisite to a zoning ordinance. They have a role in adopting and amending the zoning and land use ordinance. And when I say a role, because if it's a town meeting foreign government, they're the ones sort of putting it forward, but the town meeting actually adopts it, but they're the body that puts it forward. In council forms of government, they actually adopt it themselves. And the same thing with contract zones, which is a type of zoning. And finally, the only other role really select boards have in planning and zoning is they appoint you. So they have that authority to appoint you and remove you in some cases. And that's it, right? The actual applications themselves are your jurisdictions, and should not be subject to political pressure. Select boards are political bodies. They get elected and you don't get appointed, right? So Zoning board, I'll start very quickly with zoning board. Zoning boards are a creature of state law, unlike planning boards. There are two statutes specifically about zoning boards or boards of appeal. One gives the general rules about what a board is, and the other talks about what they can do. You have to have a zoning board or board of appeals if you have a land use ordinance. That's their zoning ordinance, I should say. That's a requirement. It's a requirement. If you have zoning ordinance, you have to have a board of appeals. And under the statute, the boards of appeals are given 3 areas that they're allowed, the jurisdiction. And towns can, by the way, expand that jurisdiction, but they have to be given these 3. Administrative appeals, that's the classic, appealing decision of a code enforcement officer. And then sometimes a planning board, depending on the town. And variances. And under variances, you can only grant variances, the legislature has said you are allowed to grant. And you still see some ordinances around the state where they're really made up variances. And it's, and there's sometimes challenges to those, sometimes not, but the statute is very clear. There's one type of variance that's required, actually I should say 2. There's 2 types of variances that are required. One is the shorthand, people call it the undue hardship variance. That's the standard variance. It's difficult. And this isn't a zoning board training. I go into a lot more detail about those standards. It's designed to be difficult on purpose. Because what you're doing is you're allowing a variance from the zoning, and the purpose of zoning is to bring things into conformity. And so when you grant a variance, you're making it non-conforming, right? So it's very difficult. And the hardest standard really to get over there is that you wouldn't have a reasonable return on your property if you didn't get your variance. It's a very difficult standard to meet as defined by the Maine Supreme Court. Essentially means you can't get anything out of it. They've overturned a variance when someone wanted to build a house lot, but it was on a lake and they said, well, you can still use it to launch your boat. That's, there's still some return there. So it's a very difficult standard. But zoning boards struggle with that. I've been on a board of zoning board, as I mentioned. So that's generally what zoning boards do. They do administrative appeals and they do variances. And I didn't know there were any zoning board members here, but I can't help myself talk about it, just saying 2 or 3 things that come up in that area. So administrative appeals, it's very important to make sure you're applying the correct standard of review when you're hearing appeal. There are 2 types of standards of review we have in case law in general. De novo, which is when you're looking at the application afresh. It's actually a new hearing, new information can be provided to you, and your decision is actually now going to be the new decision when you're done with it. And then the other kind of review is called an appellate review. That's a more light touch review. And your role in that case is deciding whether there was sufficient evidence in the record for the underlying body to make its decision. So it's not like, is it the right, I would make the same decision, but was there evidence in the record to make it, then you uphold it. What standard you apply is in your ordinance. So it's going to be different. The Maine Supreme Court has recently said, I think I mentioned this to Mike, maybe I didn't. Maine Supreme Court said in 2 cases, stronger than I usually see them dive into policy, is that they are strongly recommend that municipalities adopt ordinances that have a de novo standard of review for decisions from a code enforcement officer. Because the code, you still see appellate in that area, but the problem is, and I'm going to get into this, you need sufficient findings of fact, evidence in the record, due process, ability to provide additional information, things that, and this is the court's words, code officers are not equipped to do, right? That's not what they do. Planning boards and zoning boards do. They're adjudicator body, public comes, you take testimony, that kind of thing. So the reason why that matters is because if you have an appellate review of a code officer, it's the code officer's decision that makes its way up to the court, not the Board of Appeals. The court looks at the original decision. That's why it matters. When it's de novo, when you're looking at de novo, that board, the zoning board, that is now the new decision because you took new testimony, you took new evidence, you made your own independent decision. So that's the only thing I'd say. I think depends on the community, but I think appellate is fine for reviews of planning boards to the extent they go to your zoning board, because the planning board would have already had a big process. They know the site plan ordinances and things like that.
That's, so does the appeal of a code enforcement officer always go to the zoning board, or could you direct it to your planning board? And
Always the zoning board.
Always the zoning.
Yeah.
board.
Can they direct it back to the planning board though?
They can direct it back to the code officer, so they can remand it, we call it remanding it.
Remember?
Yeah.
Or could you do the same thing with the planning board?
Yes, if your town has an appeal of the planning board decisions to the zoning board, not every town does.
Yeah.
Then yes, one of the options is to overturn it, approve it, or remand it back for additional information. Yeah. The reason I say not every community does, because it actually is a community choice on whether you want appeals from your planning board, to have the interim step of going to your appeals board, or just have to go to the Superior Court. I'd say I work with about 50-50. There are benefits to both. I mean, some way, there's a long process, and if you're already gonna have an appellate review at the zoning board, the court's not gonna even look at that zoning board decision. Again, the court looks through the appellate decision to the original decision, so it does provide some local process, so there's a benefit to that, maybe one more step to see if we want this.
But if it's de novo,
But if it's de novo,
then the court will look at it.
that's right. They'll review that, it's called reviewing that decision. They review the de novo decision.
Isn't there a new state statute requiring land use planning to allow for more housing? The local communities need to change their ordinances or something.
Yes, that's a whole nother presentation.
And how-
LD 2003 is what you're talking about. Yeah.
So do we need legal advice as to whether our ordinances require that adjustment?
Yeah, and I know a lot of planners are doing it themselves. Michael's probably be doing that. I do review a lot of those proposed ordinances. So a lot of times my clients will have the planners or the planning boards come up with the ordinances first, and then they run it by me. But yeah, those are, I'll spend 25 seconds on it. LD 2003 requires communities to do 3 different things. One, allow accessory dwelling units for every single family.
Which we've done in Damariscotta.
The second is what we call the up to 4 units on a lot requirement, and it's up to 4 because it's somewhat complicated on whether you require 2 units or 3 units or 4 units, depending on whether the lot is in a growth zone, if it's serviced by public sewer water, if there's an existing unit on it or not. It's complicated, but essentially what it does is it requires more density. And then the third new requirement under LD 2003 is the affordable housing density law. And that, if it applies, again, there's certain places it applies, growth zone, that sort of thing, is that affordable housing density can have up to 2.5 times the base density. And you can't require additional, there's lower parking requirements and other types of things.
Is that outside of shoreline zoning?
And yes, outside of shoreline zoning.
Yeah, shoreline zoning, it doesn't change.
That's right. It explicitly does not apply within shoreline zoning, and DP's taken that position as well.
Yeah, and I can just tell you both communities are working through LD 2003 amendments.
Yeah, and the deadline was extended, it's been extended. It's already in place now for communities with town council forms of government. That was January 1 of this year, but communities with town meeting forms of government have until July 1 of this year. The only other thing I'll say about zoning, and I could talk about zoning boards a lot. I really like zoning board issues, but this is supposed to be for everybody. There's a couple variances you can look at. So I said there was this undue hardship variance to be required. There's also something called a practical difficulty variance. That's an optional variance, slightly easier on purpose. It was designed as a slightly easier type of variance. It does not have that reasonable return requirement. That's an option for a community to add. If you're finding that the undue hardship variance isn't really doing it, it's too strict for you. There's another optional variance called a setback variance for single family houses, which allows some variances up to a certain amount for a setback. And then there's an optional zoning, there's a disability variance, which allows people to get, and code officers can be given that authority in the ordinance for ramps and things like that. They're in the setback, but there's an optional one where you can allow for disability variances for essentially carports and garages, if it's required for the person to be able to get to their house. So those are in the statute. I can talk to Michael about those later, but those are for communities to decide if you want to add those into your ordinances.
What happens with a change of use to a piece of property that has a ramp? Put in there, and then you move out, and they get that through a
Right.
special exception.
Yeah.
What happens when somebody else buys that property?
It's still there. So variances run with the land.
Okay,
Yeah,
all right.
but it's a good question. I actually don't know off the top of my head if you require it to be removed or not. But as a general principle, this comes up a lot, all these run with the land. All land use approvals run with the land, not individual. So you'll see it a lot with like site plan approval, subdivision, once it's approved, it's running with that land and someone can buy it, as you know, other people can develop it. A variance is actually recorded in the registry of deeds against that property and it goes on forever, really. So you're giving permission to that lot owner to build a house close to the road, for example. And that goes in the registry so everyone understands why that happened. I'm gonna move on, because actually, I always take longer than I think. I was like, I have a half an hour material. And we're already at an hour and 10 minutes, so. Planning boards, on the other hand, and historic preservation boards, I'll put them in the same category, are not creatures of state law. They're creatures of local law. In fact, the word planning board rarely shows up in Maine statutes. Even though in some ways planning board is a more active body in most towns. The only time it really shows up is in subdivision laws. So subdivision is another law, like LD. So one question I get a lot is, can the legislature make us do this? And I say, well, here's where they've already done it. Subdivision, shoreland zoning, right? The legislature is allowed to preempt municipal home rule if they decide they want to do that, right? And they have to be explicit. And subdivision is one of those. So subdivision applies in every community. And it says your municipal reviewing authority applies that as defined as your planning board. That's where that word shows up. So, or the municipal officers, you don't have a planning board. So what's interesting, I don't even know a town, it's probably the little tiny towns. Maybe this where the municipal officers actually sit as a planning board for subdivisions. It also shows planning boards also show up in state law as the body that hears, they have to conduct a public hearing on any zoning ordinance amendment. You've probably seen that. That you literally, your job is just to have the public hearing. And then, but oftentimes communities have them provide the recommendations to the select board as well. And that's it. So the site plan ordinances you see, those are creatures of your local ordinances. Where you decide, sometimes don't have site plan review ordinances, people just go and build whatever they want. It actually always surprises me when I see that. There's sometimes still have that. But you all have a version of the site plan review ordinance, and so that's one of the areas of jurisdiction for a planning board, when it has sort of development review, if you will. Standing, this kind of gets your question a little bit on the speaking. You do have to have standing to be an applicant before either type of board. And what standing means, again, also the courts. The courts apply jurisdiction and standing. Standing means you have to have a right, title, and interest in that property to be able to be, so someone just off the street can't come and apply to build something over there. They have to show how they have a right, title, and interest in that lot over there. And what the courts have defined that as you have some legally cognizable right to use the property in the way that you're applying for permission to use it. That's what that's defined as. So, for example, a way that you would not is, say you have an easement on something, but the easement specifically says you can't, easement will maybe you specifically can't do the thing you're asking for. Well, then you wouldn't have right, title, and interest. That's right in the deed, right in the deed. But on the other hand, that requirement is fairly broad. An option contract to purchase property qualifies. As you have a legal right, you can option that, you can purchase and sale even qualifies. You see that a lot in commercial developments because a lot of commercial developers they're hedging. They don't want to buy the property if they're not going to get the approval. So you see that a lot in the commercial context where they have some sort of option contract or purchase and sale agreement with an underlying landowner pending approvals at the town level. And they just never exercise that option if they don't get their approvals. But that qualifies for right, title, and interest. You don't have one thing that comes up under both boards under this is a recent case law is that people try to sometimes have private property disputes in front of you on whether someone has right, title, and interest. Right? Like people disagree on easements is a big thing in Maine, camp roads, things like that, and people try to argue that that person doesn't have the right to build a road through there, or something like that. What the courts have said is, your bodies are not courts, and you don't have the authority or the jurisdiction to decide private property rights. If there's any question, if there's a question, it's not on its face something you can decide someone's right to an interest. You're not supposed that they've got to get a court order to come back to you. I used to say something a little different, which is just leave, if it's on its face, says they have a deed, that's enough. But there's a relatively recent case of the town of Casco that said, in the face of a dispute over the right of land, the board can't make a determination one way or the other, and you need to wait for a court to make that determination. So that's just something to keep in mind. That's something that's come up a lot. There's also standing for appeal. So the appeals body, you may not have right title interest per se. You're someone who just doesn't like the decision, but you still have to have standing. A general member of the public does not have standing to appeal, for example, a building permit across town or a site plan approval across town. The test for standing is that you have particularized injury, meaning that you are in essence an abutter. There can be slightly broader ways, but an abutter is defined differently, 500 feet, sometimes a direct abutter, but you have to have some proximity to the project. The courts have said, we don't have drive-by standing in the state. And I love that case because it was a case where people actually were driving by stuff and they didn't like the thing they were seeing. And you don't have standing to appeal that. The neighbor could, where the development was happening, but the general member of the public does not. Also, if it goes further to court, the court adds a second step to standing, so they have to have particularized injury, but you have to have also participated in the underlying appeal. So or proceeding. So you had to have actually shown up at the planning board and said something, or issued it, or the planning board, the zoning board, for that matter. And the court's gonna look, did they participate in the underlying? You can't join the process later on, if you will. Yeah, I think it was a question back there.
So that type of standing.
Yeah.
Is when a member of the public participates in a public hearing on a project. And then if it goes to appeals, then take that participation as evidence of standing.
Exactly, right.
Okay.
Yeah, and the particularized injury really is only for appeals. It's not a general public hearing, for example, the planning board. Anyone can get up and speak at a planning board. It's who has the right to appeal that decision. Yeah.
Which just makes it important that if a member of the public comes to the planning board to complain about proposed development, their name need be in the record if they're, or they
Yes.
might be excluded. We had a lengthy appeal process on the 435 Main Street development. And the people did want to make the argument that they were impacted, but they couldn't. The individuals who brought the appeal weren't the ones who showed up, and the ones who showed up were the ones who brought the appeal. And it struck me as very frustrating for the community, but we had no choice.
Right. So that's right. That is the rule.
Do you have to do anything specific if you just are at the meeting and make a comment? Or do you have to object to something? Is there?
Yeah, I think it depends. I think a court would sometimes err on the side of, if you were at least participating in any way. But there is a concept of whether you preserved an appeal. That's why I mentioned earlier on this issue of conflict of interest. I don't know how the court would come out if it was just a resident, for example, who said his general concerns. Actually, I think I do know what they come out is. They probably let it go forward. If you're showing up and it's very general, but then when the decision comes out, you actually decide to appeal on a basis that maybe you didn't raise, but it was raised throughout the proceeding and you were participating. I think that would likely meet the test. But I can't always tell you. A court would, it looks at the facts. I'm gonna move on to the topic actually that is written findings of fact. It seems very basic, but it is the biggest topic when it comes to the appeals and remands from court. Increasingly, the Maine Superior Court, but even more the Maine Law Court, will remand a decision if they determine that the findings are insufficient. I see that all the time now, where you don't get to the merits the first time around. The court will look, and the court essentially will not infer findings, is what they'll say. They won't do it. I think they used to do it back earlier in the 70s and 80s. They used to see more that if there was some discussion at the board level, at least about that standard, and there was stuff in the record, they use this term infer findings, but the court will not do that anymore. So it's very important to have findings of fact. It's actually the first thing I even look at when I get an appeal. If, we're not always there every day, we come in sometimes after the appeal's filed. And I've literally had a one-page document that says approved. Right, I've seen that. I do that less and less, but I've seen that. And if I see that now, with the town's permission, I generally, come to an agreement with opposing counsel. Say, let's remand it now. Let's just remand it now. You filed an appeal, but let's put a stay with the court, send it back so the board can make some findings. It's gonna save everyone time and money. Because instead what's gonna happen, we're gonna brief it, we're gonna go through this whole process, and 6 to 8 months later, we're gonna be right back there. So if there are insufficient findings, it's something I try to look at right away. And what does that mean, sufficient findings? Well, it's nice that you have staff. Not every community has staff. But I like to think of it as first of all, it's nice to have a checklist. It's nice to have a decision form that has the standards. It's easier for zoning boards because they usually like 4 or 5 standards to apply. And you could have like each form has a form, does it meet the reasonable return standard, that kind of thing. And under each standard, you need to have a finding. Yes, it does meet that standard because X, right? Because of something in the record that was presented to you. Even if it's one thing, even if it's one sentence, that's better than nothing. Because what the court's gonna look at is, were there sufficient, with their standard review, the appellate standard review, which is what the court's gonna apply, is were there sufficient findings in the record? And was there sufficient evidence in the record to support each finding? That's what they're gonna look at. So if you didn't have a finding at all, that's reason to remand it. And they do tend to remand it, by the way, instead of deny or grant the appeal. They do tend to remand it. Where they really want to make a decision on the merits. So they want to see why you made your decision. So if there's no decision, they'll send it back. So under each standard, make a decision, say, yes, it meets, some of them are pretty similar. Does it 20-foot setback? Yes, meets the 20-foot setback per the plans in the packet, or, per the testimony that we got. You need to have a finding under each one. The courts increasingly remand it. In some ways, it's less about the standard now, more about did you make a finding? Because an appellate standard, as I mentioned earlier, is the court's not going to step in the shoes of that body. They're not going to say they made the wrong decision. They're going to say, did they have sufficient evidence record to support their decision? That's the difference, right? So as long as you do, then you could likely be upheld. If you don't, that's when you can be overturned, or it's sort of completely opposite what the record said. That's an example where they would overturn it. The court also looks to see if you had an error of law, is the other idea. So you interpreted the ordinance incorrectly. That's where they come in and they make their own decision. They don't defer to you. Of course, that's their job, is to interpret things. So that they will look to see if you made an error of law, but the real review is about substantial evidence in the record and where there are findings under each standard. So if there's any takeaway, you have, make sure every decision has a written decision form that goes through each of the standards that are applicable to that. In historic preservation, you're doing 10 standards, make sure you have 10 standards, and that you say why it meets it or doesn't meet it under each standard.
So can I?
Yeah.
This is specific probably to me, but you all look at the documents. I put together a finding of fact and conclusion law, but the way that I've been doing it is just kind of listing out findings.
Yeah.
And just saying, like, the standard is setback 20 feet, the building's gonna be set back 25 feet. And I don't make any conclusions there, and then maybe below I'll say, I don't go get into the specifics of the setback is met.
Right.
But I'll say, the standards from this section are met.
Right.
So is that enough, or should I be doing something different? How?
No, I think that's enough, because as long as the board goes through each standard and they agree, right? So ultimately what they would do, and there's nothing wrong with staff preparing draft findings. The courts have upheld that, and some attorneys sometimes do draft findings before or after. You just have to make sure that it's the board's findings at the end of the day. So you just make sure this is drafted in what you're doing factual information, just the facts.
Yeah.
That's allowed. It helps guide the board, and then the board could take a look at that and they say, no, it doesn't meet the standard, even though you put the fact in, right? The board's decision.
Right.
But you're teeing it up in a way that's very helpful. I think that's very helpful to the board, and ensures you're gonna have at least some findings under each standard. That's the benefit of staff. Not every town has a planner, and you notice the difference. Because honestly, I mean, we're all volunteers, so it's hard to do these things. Yeah.
So the board acts on the staff recommendations of the draft findings of fact.
Yeah.
And kind of turns them into actual findings of fact by going through each standard and saying, yes, that standard has been met.
That's correct. Yep. And
And that is
refining them,
recorded in the record.
recording the record and the ultimate decision that's
And then-
sent to the
Okay.
applicant at the end of the process.
As a revised.
Yeah.
Finalized findings. of
That's
fact.
right.
Okay.
So one way it does, I don't know how you do it here, but sometimes you'll come back to the board at the next meeting. And because if there were changes throughout and the board adopts those findings. That's a good way to do it, because there inevitably will be additions to it. Or changes, and there should be changes. It shows that you're doing your own independent review. The staff's just preparing a draft document for you. But it really has to be your decision. So I always preface it that way too, when I draft findings. I'm usually drafting it after the fact, so there'll be like a hearing, a zoning board hearing, and then say, I'll draft it up, give it back to you, and the first thing I'll say is, this is my recollection of what happened, but the board needs to go through and decide if this really accurately reflects their decision, and then you vote to adopt it. That's best practice.
So I think,
Yeah.
and I think we've been doing that more recently in Newcastle, like adopting, well, we've been doing it in both places, adopting. As far as going through each standard.
Yeah.
I don't think we have been reading the entire findings of fact at each meeting.
Yeah.
But we have been. Have that and the board adopts it.
I mean, I think it's good to go through each one, even if it's basic, because it shows that you've actually read it and you're understanding it. So I think that's best practice. I have seen sometimes, however, though, if it's a very straightforward application. And you have draft findings in front of you, that the board reads it and there's a motion that you've read it, that you meet each of the standards as laid out in the draft findings. So you're making that clear that you're adopting those findings that are in there. But that also can work from time to time. But I think best practice, even though it takes longer, is to go through each one and just even have straw polls or votes on each one. And at the end, you have a final decision.
Okay, that's what I was gonna ask.
Yes.
You could have 200 standards.
That's right.
So.
Yeah.
Just to be clear, what you're suggesting or what you're recommending is to protect against the possibility of an appeal
Right.
and being remanded and then
Right.
go through this process again. That during the application review, the board not only discusses, but takes a motion and reads every single standard.
Yeah, that is
And
best
then
practice.
records
Yeah.
a reason for yes or no. I mean, we're gonna be there for hours.
Well, like I said, a lot of it can be done ahead of time if they're there's parts of those that are very straightforward and factual based, and there's very little subjectivity. There's,
I guess
so
what I-
did it
the
mean,
point of my question, I guess-
25 feet or is it 20 feet?
Right, I guess I should really get to.
Yeah.
When you say that the courts are more and more remanding for more detail essentially
Yeah.
about how you came to the decision,
That's right.
not whether or not the decision was correct.
Right.
How detailed do we, and I think that was going to what you're saying, is how detailed do we actually need to be in these findings of facts to preempt that? Like very, very detailed is what you're saying.
Well, you just have to at least point to something in the record that supports your decision. You don't need to have a treatise under each one, right? So
No, but I mean, even if you just copied the standards that were in the ordinance.
right,
And wrote a sentence about it, you're essentially providing the whole ordinance.
Yeah.
And more.
I think your question was getting at, like, in the meeting.
Yeah.
Do we read through the whole thing? And that's my concern is time and.
right.
But if it's, I guess can we save time? And obviously we're balancing that.
You can, the way you do that, and again, it is a case by case basis, and you'll know it when you see it, right? There are certain cases where this thing is getting appealed. You're paying a little extra attention to each standard. It doesn't mean you're always paying attention to the standards, I want to make that clear.
Mhm.
But there's certain ones that you want to make sure that it's clear for the record, you're gonna go through each and every one. There are other ones that are very straightforward. There's nothing in there that caused any kind of red flag of any kind. It just meets the standard. You've got some draft findings. I think it is okay as long as you've read it and someone makes the motion that we've heard this testimony, we've read the record. I've gone through each of the standards that as it's laid out here in our draft findings, and I vote that it meets those standards as laid out. That's important to say, as laid out in this document.
But that could be done as one.
That's right, that's right. That's what I'm
Okay,
getting
thank you.
at.
That's what I was getting.
Yeah, I think that's what the heart attack that was.
Yes.
I was having a little bit of a fit there.
But there are times that you go through, and there are some boards that I work with that by practice, they do every single standard, whether it's the easiest one or the hardest one.
Well, we used to have a land use ordinance that had, I don't know,
Yeah.
24 items, and they would take a motion and an action
Yeah.
on every single one of those.
Right.
And just those 24
Can
might
take a
take
long
2
time.
hours.
Right.
Right?
So I think you use your judgment on
Yeah.
whether you need to batch a motion or whether you can do it individually.
Yeah.
That on the application. The important thing is that your final written decision has finding us under each standard.
Does the county play a role in any of these appeals or any of these decisions that towns make?
No.
Concerning land use?
No, there is one new appeal, and I don't have, I'm not gonna get it right, but it has to do with, I wanna say it has to do with roads.
Easements.
Yeah, there's an appeal of, it's actually, I don't think it's discontinuance, but maybe it's abandonment. It's one of those, I don't want to do out of turn here. But that's a recent one that just came across me. That's the first time last year, where all of a sudden, and what you see though is that the counties are like, what money? They're not used to sitting in that role. But the legislature gave them a new role. It had nothing to do with your boards. It has to do with roads of some kind. Yeah, but no, the general answer is no, counties don't have much to do with land use decisions. Yep, even in the unorganized territory, that's large, or Lumpsy now. Yeah. So. That's generally what I want to talk about tonight. So I'm happy to answer any more specific questions, but that's the general overview. Yeah.
Well, at the end of the day,
Yeah.
this has all been good information,
Okay.
very informative. But on the news, this very night, just before we came down here, in one of our down east towns, the town apparently granted this company permission to build these cabins. And they were built for tourist attraction to watch the world's tallest flagpole be built. And so apparently the town has given the blessing to build these cabins, but it's against DEP's rules. They haven't applied for a permit from DEP. And DEP says you're in violation and you need to submit this application for after the fact, and they have not. And they said the deadline, this last deadline is gonna be for this Friday, and then about tonight, they hadn't filed this application. So how does the town put their blessing on this when they should have said, well, maybe you have our approval pending DEP's blessing? And that wasn't done, so this guy might have to take all these cabins down now if he doesn't get, so how does this get that far? The town, was they in violation for not, stepping in and saying, you don't have a check?
Well, I don't know about that project personally, and, but I will speak generally about the issue, which is that that a project has to comply with both sets of standards. And typically, particularly larger projects, you do need both a town approval and a DEP approval, site plan, SLOTA, they call it at the state level. Or a couple other types of permits. SLOTA is the big one, development permit. But the town doesn't have a role in that. Actually, your towns don't. You can actually get a role in that if you want to. You can have delegated authority. I don't need to go too far down that. But there are some towns that are the larger towns that have actually, essentially, they got delegated by the DEP to say, you can do it there. It's essentially a one-stop shop. And so some towns do have that authority to issue both.
They haven't given their blessing down there.
Yeah, so in the general, that's not true. And so just because you have a town approval doesn't mean you can do it. You still need your DEP approval. Sometimes you need your Army Corps approval. So there's federal approvals I see for certain projects. And there's DOT approvals, traffic movement permits. There's all kinds, some of these developments are very complicated. Each one of those required approvals are you need to get them right before. And so and they have their own appeals processes, their own. So where I see it as a municipal at times is that towns sometimes try to say, we're incorporating part of our approval is the DEP approval. I typically say you shouldn't do that because that's a body, that's a different body. You have no authority to approve it. You have no authority to enforce it. The DEP does that. What I have seen is a condition of approval is you can't get a building permit until you show that you have your DEP permit.
I think that's what I would
That's
thought
what
they
you
would
can-
have done,
I see that time too. Yeah,
but it didn't.
but sounds like it didn't happen.
I think our site plan review, we.
You require that.
As part of the process before the planning board will approve something.
Yeah.
But there was a story that in Brunswick, that they they tried to speed up the process. I have an expedited review, and then they found they got so many appeals that it overburdened staff's inability, and so they asked for a moratorium.
Okay.
I'm just wondering, could you speak to this issue of moratorium?
Sure, yeah, I get asked about moratorium a lot. Moratorium is a planning tool that the legislature has allowed municipalities to adopt. You can, your legislative body, so in your two towns, the town meeting, can decide to adopt a moratorium ordinance, and it needs to be a definitive time. So it can be 180 days at a time, that can be extended, and for a particular purpose. And the purpose has to be that there's some development that it's either overburdening of your facilities of some kind, or you have insufficient ordinances to regulate them, which is somewhat broad, right? And where you see it is you see it when a development's coming. That's when you see it. And you're typically allowed to do it. You can have a pending application, you can make them retroactive, the pending applications. In fact, most of the ones I'm asked to write is you have to have a retroactivity clause in them, specifically to make them retroactive to pending applications. In other words, something that's sitting in front of the planning board already, you can actually apply moratorium to those. There's reasons why not to. Some people don't think that's fair. That's up to the board, that's up to the body to decide if they want to make it retroactive. But yes, 180 days, and then the way the law says is the municipal officers can extend it for additional 180 period. So once the town meetings decided they want it, the boards can do another 180 extension. They're designed, however, to be planning tools, meaning you're supposed to actually be working on new ordinances during that interim. It's not just to sit there and not work. And in fact, one of the only requirements for an extension is that the need still exists, and essentially you're working on changing, you're working on getting new ordinances in place, and that's why I need additional time.
Are there been any significant changes to the site location law? Is anything coming down the road that you might know?
Not that I'm aware of. I don't work a lot with it personally, other than, some developers know that they just need it. But I would know if there's significant developments. I'm not aware of any. Yeah.
The historic preservation, we do have an ordinance, and looking at what's happened in Portland over the art museum.
Yeah.
There's an issue of granting exceptions to a general ordinance undermines the ordinance itself. But on the other hand, fear of what a historic ordinance might do leads to local opposition. So, and the board of Portland Town Council, I guess, is going to make a decision. What if they make a decision that's inconsistent with the clear language of the historic preservation ordinance? Is that something that can be then appealed to the courts? And who has final say?
Well, it depends. So if it's a decision on the merits of something, so if they're sitting on whether it applies or not, then
what can they get, or simply do they have the power to make a decision that in effect guts the ordinance?
yes. Yeah, so it's the legislative body gets to adopt ordinances, and so in Portland, it's the city council. And sometimes, so the city council, you can always change a law.
So it's spot zoning, which, in effect means you don't have zoning if you have spot zoning.
Right, so that's another, theoretical thing. So spot zoning is actually not illegal under Maine. It's actually, it's neutral, but people don't like it. You still have to comply. The only requirements for zoning is you have to comply with the comprehensive plan. But yeah, you do see spot zoning is something where you zone one parcel. Typically, when you do that is use contract zoning. And that's specifically allowed under the statute as long as you have contract zoning in your ordinance.
So like here in Damariscotta, there's what used to be called the Kensington Inn, I think. Or is it the Bristol Road?
Mm.
And it's no longer grandfathered because it's more than a year, but it's got lots of housing that theoretically could be used. But what steps would the town need to take to address that, make use of that?
I'm not sure about that. I don't know.
Yeah, I don't think we have contract zoning.
You don't have it.
in
Okay.
Nevada, so I don't.
So yeah, your contract zoning is something that's allowed by law, but you have to decide to put it in your zoning ordinance.
Yeah.
Some communities use it all the time. Some communities don't like it at all. It really depends. The idea behind contract zoning though is that there is a reason for a particular project to get its own zoning. And it is a contract. It's a contract with the legislative body, so there can be give and take with it. Like
The
your
Board of Selectmen could consider that, or the town meeting.
town meeting could consider it. That's right. That's right.
I have a question also about the Historic Preservation Commission, which is that in addition to reviewing applications, we also have a goal or an aim or a duty in the ordinance to provide an educational or an informational branch. And I was wondering about public disclosure, we need to, or public notice rather, provide notice for, the public to participate or in or observe those educational discussions and
Yeah.
sessions.
Yes, the answer is
Okay.
yes. Yeah, whenever we're getting together as a body,
Yeah.
yeah, it's a public meeting and it should be noticed. All right,
If it's all right with me to throw something out
yes,
there.
of course.
Do you mind talking just a minute about waivers and what the planning board
Sure.
can do for waivers?
I was
Because
just gonna ask that.
Yeah,
I always get that asked in the other towns I work for, and they seem to always put variances in the mix of.
very good question. And again, and that's, it allows me to talk about both boards of appeals and planning boards. So under state law, under the Board of Appeals provision, when I was talking about variances, only boards of appeals are allowed to grant variances by state law and by court cases that interpret those laws. A variance means a change from the dimensional standards in the zoning ordinance. Another way to put it is space and bulk, you see that terminology, it's height, setback, lot size, density by zone. Zoning means you treat different parts of town differently. That's what zoning actually is defined as. So zoning ordinance is when you have different zones and you've got different rules for each of those zones. Only a Board of Appeals can grant a variance from that. Planning boards can grant what we call waivers. Sometimes you see the word variance in the old statute. It doesn't mean the same thing and we shouldn't use that word. But you'll see variance. And planning boards can grant waivers from standards, general standards of applicability in a site plan review ordinance, for example, or a subdivision ordinance. Those are ordinances that are not zoning ordinances. Those are land use ordinances that apply throughout the town equally. Right, and no matter what the application is, you've got to apply for site plan review and you go through the standard. That's why it's considered different. It's not zoning. And they're not these space and bulk requirements. It's typically things like road standards, sidewalks, buffering, design details sometimes, particularly in form-based codes, and things like that. So that's the difference. It's a subtlety, but it's very important. Planning boards, sometimes I do see planning boards try to grant a variance from the setback standards. You're not allowed to do that. That would be overstepping. There's one exception, and that's for cluster developments, or in the statute for variances says a municipality can give a planning board the authority to vary standards for cluster subdivisions, cluster developments. But you have to make sure you draft that language in a way that is clear what they're doing. So that's a type of development where you want to allow some flexibility to allow for increased density and open space. So instead of one house on 1 acre, you have 10 acres, or 10 lots. You might be able to still get 10 lots, but you'll put on a 1/4 acre and have conservation land. So it's that type of thing.
Park or playground.
Exactly. So it's a specific type of development, it's a very specific exception to the rule. And you have to be it has to be an ordinance. But that's the very general overview is variance, boards of appeals, waivers, planning boards. And planning boards have to be given the authority in their ordinance. You have to point to where they have the authority to grant. Sometimes the waiver language says planning board can grant a waiver, except for these things. You never want to waive those things. So you have to look at the language of your waiver.
Does a waiver cover the whole district?
The whole town, yeah, it's a townwide standard.
When the planning board gives
A waiver.
a waiver,
Yeah.
does that cover, does anybody, then do they have to, can they use that same standard that's the waiver's been given? Any place they want, or do they have to?
No,
Yeah,
it's specific to that application.
okay.
Yeah, it's specific to that project.
Mhm.
Yeah, and in fact, the rule says you have to vote on it. So you have to vote to grant the waiver. So there's a request made to you as part of the application,
The town has to vote on it?
the
or-
planning board. So you'll see the application sometimes, it'll be like, here's our new grocery store.
Mhm.
Here's how we meet the standards. However, we're specifically asking for a waiver from the parking. There's too many parkings. We don't need that much parking, so we want a waiver. And as long as your ordinance says you can waive that and allow reduced parking. The board, as part of its review of the standards, would also say, do we agree that they should get a waiver
Yeah.
on the parking requirement, for example?
Do you need to provide any kind of reason or justification or?
Yeah, again, it actually depends on the ordinance. So some of them are pretty strict. I've seen some that will say that it will they almost use the old undue hardship or others will just say in the best interest of the project. Like, it just makes sense. You'll see the way, yeah, it makes sense to not require that much parking. We really don't need 100 spots. It's really more of a. Well, the kind of last thing I'll say, I think, and this sort of question is, but that leads me to think, if you're granting a lot of waivers. And you're hearing a lot of variances, that means you might want to take a look at your ordinance. That's what I have to say, because it means that the ordinance may not be reflective of the kinds of development that are going on, and that maybe it hasn't been updated for a while, and like parking, I thought of it with parking, but I say this in my zoning board presentation. Is if you start seeing 10 variances, and sometimes really do get 10 variances, sometimes never, but it's always for the same thing, right? It's just not working. We have a 50-foot setback, and that district, all the other houses are like 30 feet from the road. You may want to think about, do we really need a 50-foot setback? We're getting all these variance requests. You know, it's a policy decision for the town to decide. Maybe we just move it to 30. But that's a decision for the town.
That reminds me of a situation where, a few years ago, the planning board kept getting asked for waivers in the initial application.
Yeah.
And so finally, we amended the site plan review ordinance to say that whether or not you are seeking a waiver, you must submit a plan that's fully compliant. So that if we don't grant the waiver.
Oh, interesting. Okay.
So
Show like with a waiver or without a waiver.
So so people know there's a choice.
Right.
And that you just ignored the ordinance and asked for waiver rather than trying to comply.
Right.
So we now require you to try to show what it would be if you did comply.
Yeah. I see that the other place I see that is in the cluster subdivision or conservation subdivision. You typically show what the traditional layout would look like and what you're proposing, how that would change. Yeah. All right. Any other questions? Been here long enough. Thanks for having me. I
Thank you.
appreciate it. Yeah, thank you very much.